Good morning. Welcome to another edition of Legal Access. Today we're going to be talking about one of our most popular topics, very lively, very popular as far as phone calls are concerned, so don't wait to the very end to try to get your phone calls in as we talk about HOA law today. I know a lot of people have thoughts about their own HOAs. If you have any specific questions or general questions, make sure and get them in here today to Legal Access. Phone number is on your screen. Give us a call, but like I said, don't wait to the very end of the show. We might not be able to fit you in. Here on the panel to answer your questions for us today, first of all, on my left, from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
Also want to welcome back Mark Napier.
Thanks, Dave. Good to see you.
And down at the end of the table, for no specific reason, Sam Stathos.
Thanks, Dave.
Yeah, it's great to have both Mark and Sam. They do a fantastic job with HOA. And like you said, Dave, or Echo, it's always a popular topic. So if you're going to get your calls in early at 843-848-8080. That's 843-848-8080. Mark, tell us a little about your firm. I know you're in Murrells Inlet.
Right.
And what kind of laws do you do besides HOA?
Yeah, our firm is Inlet Law. We're located in Murrells Inlet. We do a little bit of everything. I do everything from civil litigation, personal injury work, to doing, of course, homeowners association work, and have a partner who does a lot of residential real estate and estate planning, and then we have somebody who also does the criminal work. So
you got it covered.
A little bit of everything.
And
yeah.
excellent law firm, excellent attorneys, and we're always honored to have you on the show. And of course, Sam, another fantastic attorney, and Sam, you're at Patrick and Stathos, is that right?
That's right.
And you're also down the south end.
That's correct.
And tell us about your firm.
So, like Mark, we're a little further south. We're down in Surfside Beach. Our firm does homeowners association law, some transactional work, meaning commercial and residential real estate, and civil litigation. We have an associate attorney, so there are two of us, and because of real estate and homeowners association law, we oftentimes end up doing some corporate work. Estate planning comes into, or estate administration comes into the picture. So it's an interesting intersection of many areas of the law that you don't anticipate. So we kind of like Mark's firm, we don't cover everything, but we do cover that, what people might refer to mostly as dirt law.
Yeah. And especially here at the beach, it's very prevalent and very needed. So it's great to have you both, and we always love having you both on the show. So thank you.
And one of the reasons here at the beach it's very needed is because, as we mentioned several times before, according to the Department of Consumer Affairs in South Carolina, Horry County leads the state in the number of complaints about HOA restrictions and laws. Now, number 2 is Richland County, so we've beaten Columbia for something here. So what are the number 1 complaints, Mark and Sam, that you get as far as HOAs are concerned from HOA members?
Usually it's complaints about not being allowed to do something with their yard, or being fined regarding something with the yard, and hey, the guy down the street's able to do it, why can't I do it? That's probably one of the biggest issues that I see.
Something like along those lines as well. Sometimes lack of transparency or communication. Some homeowners perceive the board or the management company may not be as forthright from their perception with information that they are getting, and so there's that. And then to echo what Mark just said, the appearance of an inconsistency in enforcing the HOA governing documents. You know, by way of example, my neighbor was able to get that particular place set in their backyard, but I'm not permitted, and you know, those issues seem to come up more often than you'd imagine.
So if somebody has an issue that seems a little bit more simple, like the ones that you're talking about, what are some of the things they can do to resolve those situations without talking to an attorney?
Well, I usually say first talk to the management company. Most of them have a management company, and they should at least start there. The next step would be talking to your board members. I mean, they're supposed to be your representatives, so talk to them, attend the board meetings, you know, and hopefully you can get some satisfaction that way, as opposed to having to go to hire an attorney. That should be the last resort. I mean, really, it should be the last resort.
That ends up costing everybody money, right?
It does. It does. Yeah.
Now, as far as meetings are concerned, a lot of people have called in the past as far as the HOA shows are concerned. They're like, we never have meetings. Whenever meetings are there, we don't know about them. If somebody is in an HOA but they are complaining about never having a chance to have input, what can they do to kind of prod things along to make sure that there is meetings that they can have some say as to what's going on in their neighborhood?
That issue does come up. We hear that from homeowners, and I think one is make sure from the outset that your property management company, your homeowners association has your correct contact information. I know that may seem simple, but it's your initial way of getting information about when the meetings are taking place, when the board meets, when you have your annual meetings. That's the primary point of communication. If you're not getting it consistently and you're getting your information from, say, a social media site, say, for argument's sake, many homeowners association may have a website, but it's not managed by your homeowners association, it might be by a group of neighbors, and sometimes you get misinformation. Go to the source, go to your property manager, go to your board members, as Mark said, they're your representatives, talk to them and get that information so you'll know when the meetings happen, and frankly have a direct line of communication on what's going on with your neighborhood, as opposed to relying on something that somebody else may have told you or that you read on a Facebook page.
Phone lines are open in case you have any questions about our topic today, which is HOA law. Don't be shy. 848-8080 is our phone number. Now, some people have called up in the past. Is there any restrictions on how much an HOA can raise their fees and dues? Or is it just kind of unrestricted?
Well, some of everything goes back to the governing documents, and sometimes the governing documents do put caps on how much the assessments can be raised. For the most part, it comes down to what is the budget. They're supposed to do a budget every year, and once they do a budget, then you divvy it up and you amongst the owners, and that's what it is. But there are at times limitations in place, and if those are in place, then of course those apply. But otherwise, there are no restrictions statutorily.
Yeah. And one thing that does come up when you're talking about a budget, and in particular the last couple of years that I've seen with condo associations in particular, have been trying to address the increase in insurance costs. Insurance premiums have risen to the point where you see condo associations having to special assess in order to cover their costs. And like many things, usually they don't go in the other direction. They'll continue to be at a certain level, and it's an issue with budgeting and that. Well, to Mark's point, there may be limitations in the governing document. If you have something where it's a budget item, we need to address that, then your costs will increase. And one vehicle that they do have is a special assessment.
I'm going to take a quick little break right now. When we get back, we'd love to take your phone calls. If you have any questions about HOA law, today's the day to get those questions answered. Give us a call. Phone number is on your screen. It is Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Today, one of our popular topics, HOA law. It always is very lively and very busy as far as the phones are concerned. So we do have a couple of people on hold right now, but if you want to get in, phone lines, we have a couple that are open still, and the number's on your screen, so call in and we'll get you on the air. First off, let's go to North Myrtle Beach. Cindy is on the line with us right now. Hi, Cindy. Thanks for holding through the break. What's your question for us today?
Hi, good afternoon. My question is, we are a 15-home small HOA community in North Myrtle Beach, and we have a homeowner that wants to do short-term rental. Our bylaws had stated originally no commercial business or activity would be conducted on properties. Does that stand for short-term rental?
I usually do not believe that is considered a commercial activity. I think if you're going to limit rentals, you need to have very specific language in your governing covenants, which specifically address rentals and state, rentals have to be at least 6 months or a year or whatever limitation you're talking about, and have that change, if it's not in there now, have that change approved by the, whatever the proper amendment amount is, requires. And that's of course set forth in your documents.
Yeah. I'll echo that. Unless it's expressly stated
Right.
in the document, I think you're going to have a hard time trying to enforce something if it's not in there.
All right, Cindy, thanks for your phone call. That's one of the questions I had, so I appreciate you getting that off my plate here. But let's go ahead and go to our next caller down to Murrells Inlet. Bill is on the line with us right now. Hi, Bill. Thanks for hanging on. What's your question today?
Yes, sir. Good afternoon. Thank you for taking my call.
Absolutely.
This is in reference to commercial vehicles parked on residential property. We've been trying to solve this and resolve this situation over the past couple of years, and the homeowner has kind of been fighting us on it and giving us different excuses and telling us that the vehicle is used for their husband to go back and forth to work with, and we never see the vehicle leave on emergency calls or over the weekends. It's always parked in the driveway, and certified letters have been sent out to them. They refuse to sign for them, and I'm wondering how we might be able to resolve this.
So I'll jump in here. The first thing that I would recommend is certainly following whatever the governing documents are. I know you'll hear that from us a lot, because that's how HOAs are governed. And specifically look at what rules and regulations you have with regard to which vehicles are permitted to be on the property during the course of a day. And if there's a definition for a commercial vehicle, I know Bill used those terms, so I'm assuming there's a specific term and a specific perhaps description and weight of what the vehicle is that isn't permitted to be in this HOA. The enforcement component is one that is always, in my opinion, a difficult one, primarily because to the homeowner's description of what they're doing, perhaps it's not there for a 24-hour period, perhaps it's there less. But in order to enforce it, I think you're relegated to going by your governing documents and following what those permit you to do with communications, with any fines such as they are. And if you're finding no resolution that way, sometimes you do have to go to an attorney to help you navigate that with enforcing it. I'm not saying it's an easy thing. It can be difficult because there are a lot of facts here that we're not familiar with, in particular, from the homeowner's perspective, but from the HOA's perspective, you need to follow your governing documents, and when you can't find solution amicably within the property management process or your governing documents, then you're probably relegated to going to an attorney.
Yeah, just to touch on your first part, I think the question of what is a commercial vehicle is first and foremost the question, and you need to look to see what the documents say even about that, because there's a statutory definition for a commercial vehicle, but I've seen associations where they say if somebody slaps a sign on the side of their vehicle, it's a commercial vehicle and therefore is prohibited unless it's sitting in the garage, or they peel the signs off, So I think that has become a big issue in a lot of places, is all they'll say is no commercial vehicles without a definition, and then you got a problem.
Yeah, I can't disagree at all with that.
Yeah.
Well, if logos, and I'll just be devil's advocate here, if logos are what they're afraid of as far as on the side of a truck, what about if somebody who is a police officer drives home their police vehicle and parks it in their yard because they've got logos all over that?
Sure, and that has come up. A lot of times they'll have exceptions for emergency type vehicles. I've seen that, but I have also seen where in some cases an association has actually taken that on as well and tried to prevent a police officer from being, which is obviously not a good idea. But I've seen it. You'd be surprised at what people have deemed to be commercial vehicles. And sometimes it's, well, does the truck have those bins on the side,
Right.
that a lot of service trucks, then they consider it commercial. It just depends. It really does.
What if you have an HOA that has promised a lot of different amenities, like maybe a pool, clubhouse, repaving, a new gate, whatever the case may be, and you're paying into this and they have not taken any action into giving these amenities to the community?
Well, so I'm going to step back on that. One of the things that homeowners, HOAs should have are what we refer to as a reserve account. Usually reserve accounts are one to maintain and repair. And then there could be a capital account. The capital account being for these amenities and these improvements that are part of their to your point, promises. So, we always look at it from at least contractual standpoint. A promise, can be an advertisement, but is that written down in the governing documents that this is what this association is going to provide? That's the beginning point, in my opinion, is to determine what has been represented and is in the governing documents that represents that that's going to happen, and then, frankly, have they budgeted correctly for it, and do those funds actually exist, and are they being applied towards the end result, right? Is it something that's maintaining and repairing something, or is it we're going to, we have a tennis court, but we're going to put a pool next door, and now we're using that capital account for that purpose? That's, it's a burden on developers to set these up at the beginning before they turn them over to the homeowners. And sometimes there is a rub there that I've seen where in that transition process, those accounts may not have the adequate reserves or funds that they need to have.
That's exactly right, because a lot of the associations and they pride themselves on saying no increase in dues this year, no increase in dues again, and they do it year after year after year, and everybody knows all these other costs are going up, and if you're not budgeting for things like what you're talking about, then you got a big problem when all of a sudden something does break down finally, and it's going to be a special assessment, or if it's a capital account that's been underfunded, and suddenly the assessments just shoot up as opposed to just a little gradual increase. It could be a real problem.
Going to run to another little break here right now. When we get back, we'll still have about 10 minutes left to get you on the air. So if you have any last minute questions about HOA law, don't be shy. Get those questions in. Phone numbers on your screen. We would love to hear from you here today on Legal Access, brought to you by the McGuire Law Firm. All right, just under 10 minutes left. That's your countdown as far as getting your phone calls in on today's show. HOA law, always very lively, always very tough to get phone calls in, so we want to be able to fit you in. If you have any questions about HOA law today, we've got our panel to be able to answer those questions for you. Got Ian McGuire from the McGuire Law Firm, also Mark Napier and Sam Stathos. Appreciate everybody being here and appreciate you listening and watching here today. Do we have Ruth available on the phone with us right now? Ruth, are you there? Go ahead. What's your question for the panel today? I don't know. I think I may have jumped the gun. I don't know if Ruth was ready. So let's go ahead and ask a couple of questions here now. Are HOAs allowed to ask individual landowners within the properties to put them on an insurance rider so that the HOAs will not be responsible for any accidents that happen on the property owner's property?
I'm not familiar with that. I haven't come across that.
Okay.
And I would be surprised if they would be able to do that.
Yeah, and when you're talking about, where you have covenants in place, now, usually that's not. Now, in a condo situation, they do sometimes require that people have HO6 policies to protect, their personal belongings, and sometimes it is required that they have it, as opposed to just saying we suggest it, because usually the policy for the association will not cover that kind of stuff.
Yeah.
All right, I think we do have Ruth available for us right now. Hi, Ruth. Thanks for hanging on. What's your question for the panel today? Ruth, you there? Maybe I jumped the gun. Going back to condos here for just a second. If somebody has some sort of a water accident in a condo, like say upstairs, and it leaks through into your apartment or your condo, is the HOA responsible for any of that, or is it just the person upstairs who made some sort of a a bonehead mistake with their bathtub or shower.
So that's going to be factually, that'll be the point of the beginning point of the analysis. Where did the actual, where's the origin of the leak? And if it's the, as in the master deed describes what the condo, what that is, right? And if it is a pipe, say, that's unique to that particular unit, and it's the responsibility of the owner to maintain, then it's likely that it's going to be the owner's burden, and they're responsible. Now, I'm not a plumber, but plumbing seems to be complicated, and sometimes there could be this analysis that says, well, it's the owner, but the HOA also has the main pipe, which may have caused a condition that then exacerbated into the owners. And so, but that's the starting point. And if it is indeed found, factually everybody agrees it's the owner's pipe, for argument's sake, then that's going to come into play. But to follow up on something that Mark said earlier, that's a reason some condo associations will require you to have that HO6 policy, because it covers your contents and there's a liability component that can address, maybe not fully, but to some extent, some of the damages that occur as a result of something of that nature.
Well, yeah, and let's say, okay, let's play devil's advocate though for a minute, and upstairs neighbors' pipe did leak, but never had a problem with it. Say it's relatively new. There's an issue. Was he negligent? Did he, had never had a problem with it before? It may be a real question of fact and question of law as to whether or not they can be held responsible, or sometimes it just happens, which is why you tell everybody to have their HO6 policy, because sometimes you can't hold somebody responsible. As they say in some of the commercial, bad things sometimes just happen, and that could be the case.
Staying with that scenario, who's responsible for inspecting whose fault that is? Does the HOA hire somebody to do that, or does the homeowner hire somebody to do that? Because if HOA hires somebody, the homeowner is going to complain if the result doesn't go their way.
Let's just say the homeowners association starts and a claim is made, an insurance adjuster will come out to determine from their perspective, who's the at-fault party. And there could be, to Mark's point, there could be competing factual parts of that, because your HO6 policy is going to have its own and conduct its own investigation, perhaps bring its own adjuster in. And if the two don't agree, you've got a factual issue, which unfortunately is going to be something that may need to be litigated, or at least worked out in some mediation or other type of a litigation process.
I know a couple years ago that they passed laws in South Carolina that HOA rules have to be disclosed to any new occupant or any new buyer. Are there any more laws on the books, or any new laws that are being discussed in Columbia that you guys are aware of as far as HOAs go?
I don't believe that there is anything new coming. I think we hear rumblings all the time, because, as you know, people are always griping about HOAs, but I don't believe that there's anything imminent at this time.
Yeah, and I think that one of the, the Department of Consumer Affairs keeps those statistics you referenced earlier, but it's my understanding they're mostly there. They have these statistics. They may have some way to try to help people make a complaint, but then it's up to the General Assembly to review these and then make a determination if they believe that we need to address whatever whatever these facts, this data shows to us as far as any statutes are concerned. But to Mark's point, I'm not aware of anything on the horizon other than grumblings.
A lot of grumblings as far as HOA law is concerned.
Always.
Tell you what, if you have any other grumblings or other questions about HOA law and you weren't able to call in today, make sure and email us and we'll answer those questions when we get off the air. legalaccess@WMBFnews.com is our email address. And next week when we get together, criminal law is going to be our topic. So if you have any questions